SJC-10255, Commonwealth versus Gomes.
Good morning, Ms. Merrill.
Good morning, Your Honors. May it please the Court, I'm Dale Merrill, representing the defendant Paul Gomes, and with me this morning is also Attorney Dana Currahan. There are 5 issues that we briefed in this matter, Your Honors, and the first of them deals with the issue of the motion to suppress. This is a situation where Mr. Gomes and a companion were out on the street, on Stewart Street, early in the morning. The police rounded the corner in a caravan of 3 police cars, 4 officers, driving up the street in the wrong direction, approaching Mr. Gomes. What they saw at that point was they saw Mr. Gomes showing something.
Could I, I'm sorry to interrupt you, but just in terms of the big picture, I read in the Commonwealth brief that the police had observed Mr. Gomes earlier that night. It wasn't the first time they saw him when they drove up the street. Is that right?
Yes, Your Honor.
So they had observed him several times. This is 4 o'clock in the morning now.
Correct.
So they had seen him earlier that morning.
Correct.
In that area,
Yes.
which they understood to be a high-crime drug area.
Yes, Your Honor.
Okay, so I just wanted
Sure.
to make sure I had that part right.
Your Honor, this is an area that also houses the Transportation Center, the Wang Center, many theaters,
Right.
many bars, restaurants, New England School of Law.
Is there anything open in the was there any evidence whether anything was open in the Transportation Center at that time of the morning?
There was evidence that there was Store 24, Little Peach was open, that there were various Store 24 types of facilities open. You have restaurants in that neighborhood. You have
But for
hotels.
purposes of the motion to suppress, I mean, the officers could testify, and they did testify about their experience on that corner and in that area as being a place of many drug transactions and a place where they had themselves made many arrests, right?
Yes, and we'd argue that that would actually also be prejudicial to be arguing
Well,
that.
your argument
Well-
goes to the trial, but we're talking now about the motion to suppress, I think, aren't we?
Correct, Your Honor.
So,
The police had made arrests in that neighborhood, but there are also many citizens who lived and worked in that area who would still be entitled to constitutional protections, Your Honor. And simply because Mr. Gomes was out at that hour at a time that people who might be coming or going to work, who may have worked at the Transportation Center or any of the restaurants, hotels in the area, or tourists, let's say, arriving late at a hotel or early in the morning, still would have been entitled to those constitutional protections. The mere fact that those restaurants, that those stores are open, and there was quite a bit of traffic in terms of people during that time in the morning, suggests that there were enough people out there who were not committing crimes, who were going to Store 24, 7-Eleven, Little Peach.
You make the point the defendant would argue that suppression of all the cocaine was properly preserved. What do you mean by that?
We would argue that the defendant did file a motion to suppress. While he did not object during trial, the intent was very clear that he did want to suppress.
Have we stated whether that's considered to preserve the error?
My position is that it would be the attorney's intent to have preserved it. If this court was determined that it was not preserved, then it would be ineffective assistance of counsel, Your Honor, and that it would be under a substantial likelihood of miscarriage of justice at minimum, Your Honor. And in this situation, we feel that this really is kind of outrageous. This case really is very close to the Wooten case, Your Honor, where police observed a party in the same neighborhood, and where the court said that simply observing somebody is okay. And that's what happened initially, was the police observed Mr. Gomes showing something to Mr. Bates. They didn't know what it was. Now, under the Wooten case, it would have been okay for them.
Didn't they also see him swallow something?
Yes, Your Honor, but in our society, if you're taking something like candy or breath mint, it's common. You offer it to your companion before you pop it in your own mouth. That's common manners that our parents taught us when we were children.
It is, but the trial court judge, or at least, and I haven't read the testimony, the trial court judge sort of, in his findings, suggests that the swallowing took place when the police presence became known, which suggests he wasn't popping gum in his mouth. He saw the police and quickly popped something in his mouth, which the police could conclude might be a drug. At least that's how I understand the findings of the trial judge.
I think that when you're in reading the case, what actually happened is as the police pulled up to Mr. Gomes and Mr. Bates, they quickly hopped out of their car. And this is a very quickly evolving situation. Whether Mr. Gomes was, in the process of popping something into his mouth, saying, just companion here, would you like this, and then popping something into his mouth, it is a matter that, in a very, very quickly evolving situation, we can't
Well,
look into
let's
Mr.
assume for a
Gomes's-
moment. Let's assume for a moment we credit the judge's findings that he popped the thing into his mouth when police presence became known. All right. Doesn't that, combined with the other circumstances, give them reasonable suspicion, at least for the initial seizure?
It may be an additional factor, and actually, when the search, when the seizure begins, actually is very important in this matter. Did the seizure, occur as the police jumped from their car and were running towards Mr. Gomes, versus a few moments?
Why is
should
it
it
so
begin?
important here? If, in fact, the seizure doesn't take place until the swallowing,
Well,
you're saying the seizure took place before the swallowing?
Yes, Your Honor.
Because the swallowing seems to me to be a relatively important fact here.
Well, it certainly could be a factor, Your Honor, but it also could be indicative of very innocent behavior of offering a companion.
It could be. It could be.
Excuse
Well, we're
me,
talking
Miss-
reasonable suspicion.
Miss Merrill, excuse me, it's the chief talking.
Pardon me.
It's okay. What the judge finds is as the police cruisers approached, Mr. Gomes put his right hand to his mouth and appeared to swallow something.
And I'm not sure from the evidence that was correct. It seemed like it was more of a quickly evolving situation.
And he says and then the next sentence is, the officers exited their vehicles and approached Gomes. So the swallowing had occurred before any seizure, unless approaching cruisers or seizures.
And my memory of the facts was that the police actually exited their vehicle, and as they're exiting, that Mr. Gomes swallowed the object that he had, be it candy or gum or whatever. But that's my memory of the facts. And certainly, that would be a factor, but it would be a critical factor in the equation as to whether or not adding one more factor in terms of there being reasonable suspicion. But we would still argue that since that's indicative of very innocent behavior, that wasn't enough. And that what they still had was two gentlemen on a street corner in a doorway in the middle of December, possibly staying out of the cold.
With
And-
one facing away, as I recall the facts.
Correct.
Mr. Gomes had his back to the street, right?
Yes, Your Honor.
And the other person was looking out towards the street.
Correct, Your Honor.
I mean,
And-
the fact that there may be innocent explanations doesn't mean that the police were unable to draw not-so-innocent explanations for these series of facts put together.
But, Your Honor, I would argue that was really more of a hunch at that point, that really hadn't manifested itself as reasonable suspicion. That possibly...
I think here again, we just have to look at the judge's ruling, and with respect to, I don't think that anybody challenges that the stop occurred when they declared their intent to frisk the defendant, correct? he was not free to leave.
At least at that point, he was not.
Correct.
free.
He was not, as soon as the police were exiting the vehicle, I would argue, Mr. Gomes felt that he was not free to
And then the
leave.
judge very helpfully describes exactly why he thinks the police had a reasonable basis to conclude the criminal activity was taking, specifically drug dealing was taking place, activities they observed, the display of an apparently small object in the hand to another, followed quickly by the evidence swallowing of that object, displayed when police presence became known. Was there evidence that the police presence was known at that point?
I'm sorry, Your
Was
Honor.
there evidence that the police presence was known at that point?
The police were pulling up and they were rushing towards Mr.
Okay.
Gomes, Your Honor.
And the judge concludes that this is highly suggestive of a drug transaction. Moreover, they knew this particular person as a person who had previously been arrested for drug dealing, and then he goes onto the photographs, and you're simply saying that's insufficient.
Your Honor, I would say that he was known in a prior neighborhood a few years earlier for this problem. There wasn't any, I looked at other cases the Commonwealth quoted. In those cases, they're either open matters before the courts regarding drug transactions or very recent cases. The cases of Mr. Gomes being known to the police happened in a totally different neighborhood and in a time that was significantly past.
Can we
It
turn
wasn't
to the Pat?
current.
Can we turn to the Pat Frisk? You say that obviously, and it is a two-part analysis. Let's assume there's reasonable suspicion for the stop. Now there's got to be an articulable basis that there's some danger posed. Why do you say that a Pat Frisk was not appropriate here?
While the police said that made a generalized comment about there being, gun cases, they didn't specifically say in that neighborhood, and they didn't specifically tie it to Mr. Gomes.
No report of gunshots that night, or of
There was nothing like that, Your Honor.
no report of him having a prior record involving guns or prior involvement with weapons.
There was nothing in his record showing
the-
prior.
No
use
furtive
of
movements. No furtive movements here.
There are no furtive movements, Your Honor. He didn't have any stiff arm cases where he was holding anything in a manner. He wasn't reaching towards his
But
waistband.
it was 4 in the morning, and it wasn't, I mean, the judge made findings about shootings in the area. I mean, maybe they weren't that day, but that they were not uncommon in that area.
The police actually said that they had problems with shootings, and it was very generalized. It didn't make reference to that specific neighborhood, that corner of Stewart Street and Tremont Street, Your Honor. And certainly throughout the city of Boston, there are shootings.
I'm
But
wondering I don't mean to interrupt you and finish what you're saying, but I'm hoping you will get to the expert issue.
sure. In terms of the expert issue, we have a situation where there was no testimony whatsoever presented. Normally, the courts allow a prosecutor to put forward a police officer and qualify them as an expert. In this matter, nobody testified as an expert. This left the jury floundering about, guessing at what really was enough quantity, packaging, and what they should really do with this information.
Well, just so I'm clear, he had 11 packets initially that fell out of his pants, and then 45 were found at the police station. Is that right?
I think it was 5 at the scene and
5
and
plus
45 later.
45?
Your Honor. But, this is measured in grams, and you have to look at how many people really understand what is a gram. Is a gram a lot? Is it not a lot? These are people that really don't have any criminal background. They don't have any exposure. They don't know what a lot is or what a little is or what's indicative of personal use.
So the defendant's position was these 50 bags of crack are all for my personal use.
Well, what I'm saying is that the jury didn't know if 50 bags was a lot or if it wasn't. Is this somebody who is, buying something, a larger quantity, simply because they minimize the risk of later being caught? The more times you're out there buying something, the more likely you are to be
By the
caught.
way, going back to our facts, that other fellow who was standing there with the defendant, when the police came, they checked him. He didn't have any drugs on his person, right?
Correct, Your Honor.
And he was allowed to go?
Yes, Your Honor, so there's no evidence as to who sold whom the drugs. We don't know if Mr. Bates sold them to Mr. Gomes or Mr. Gomes sold them to Mr. Bates.
Well,
It was
if you can get over the hurdle that there's expert testimony that he's a distributor, it's pretty clear who's selling who.
Pardon me, Your Honor?
I know, I said, if you can get over the hurdle of lack of expert testimony, I don't see how you can argue that it's unclear who's the seller and who's the buyer.
Well, actually, the police didn't see anything transfer hands. So we don't know if Mr. Gomes had that earlier. And there's no evidence of like a larger stash anyplace, nothing like that. Now, if the police had perhaps waited...
He had the stash on him.
Pardon me?
He had the stash on him.
Well, we don't have an expert to tell us if that was a lot or if that was for personal use. Now, we would argue that the best practice would be to have an independent party arguing, but the courts have allowed police to argue that and be the expert. But just as in the Wooten case, there wasn't enough evidence to show in terms of somebody actually testifying and allowing the jury to make a decision appropriately.
Thank you, Ms. Merrill.
Thank you.
Ms. Blennon?
Good morning, Your Honors. May it please the Court, Lynn Brennan on behalf of the Commonwealth.
Ms. Brennan, I'm sorry, go ahead.
With me is the trial prosecutor, Assistant District Attorney Philip O'Brien.
Why did the Commonwealth not present an expert in this case?
The record is unclear as to why the Commonwealth did not present an expert in this case, but I would suggest that they were not required to. And before I address...
I know the record isn't clear. I'm curious. Is there a reason that of which you're aware? I didn't find any reason in the record.
I'm not aware.
Okay.
I'd have to go off the record.
Okay. By the way, had the defendant been convicted or just arrested previously for prior drug offenses? Judge Brady said arrested, but you keep saying convicted.
Convicted.
But Judge Brady said in his findings that the defendant had been arrested.
He did. I noticed, Your Honor, that there were two instances in which I think that Judge Brady perhaps did not make correct findings of fact. That was one. The testimony at the suppression hearing was that the defendant was a known impact player in the Grove Hall neighborhood and that he had prior convictions for serious drug offenses.
Okay. And are you aware of any case that says that a pat frisk is permissible based on a high crime area late at night and the belief that the defendant is dealing drugs?
I'm not specifically aware of that, but this fact pattern is distinguishable in that, and counsel argued that the testimony was unclear or ambiguous as to shootings in the area. The testimony was quite clear, and I refer Your Honors to page 34 of the motion to suppress.
Well, I think I included that. I
transcripts.
said based on a high crime area.
Yes,
I was including that.
But this specifically is the fact that officers had been shot at, which sets this apart from your typical high crime area where there might be a high prevalence of drug activity.
When had they been shot at? This is downtown. This is in the center of the theater district.
Correct, but
I assume at some point an officer has been shot at almost anywhere in downtown Boston. How does it relate to this scenario?
only in that when the officer testified as to the reasons why he felt that for officer safety a pat frisk was necessary, he went back to or relied upon the fact that there had been a lot of shootings in that area, not a random shooting, but a lot of shootings in that area, police-involved shootings in which police officers had been shot at.
When?
We don't know.
Do we
In the
have,
history of that area? I mean, this is very difficult because I take it that means that any time you stop anybody in that area, who knows? There was a shooting here once. Maybe this person's armed. Is that sufficient? Is that what pat frisk is based on?
Certainly it's not sufficient. There should have been some record of or some testimony of the proximity and time of the prior shootings. But I would still suggest that the court could reasonably consider that there were officers that were shot at. Your Honor is correct that there should have been some temporal connection. But that, taken with the fact that it was a high crime area, which the court has validly stated, of course, that alone, that factor has to be addressed with some caution.
Ms. Glennon, may I ask you if both men were pat-frisked?
The evidence on the record is that the defendant was pat-frisked. Well, actually, I think the answer is yes. I was going to say that, and that the second individual, Mr. Bates, was FIO'd, or field interrogation.
You say that
officer,
in
but I
your
think he was
brief.
pat-frisked as well.
You say, fifth, the other man was pat-frisked and promptly released, and cite to transcript, volume 1, page 68.
Yes.
So he was pat-frisked?
Yes. My first response was going to be that he was FIO'd, but he was pat-frisked and promptly released. The inference that can be drawn from that, of course, was that he did not have any drugs on his person. He was not arrested. He was not summoned into court.
Pat frisk is for weapons. A pat frisk is for weapons. How can we draw the inference that he didn't have any drugs on his person?
All you can draw
I
an inference
suppose-
is that they didn't come out of his pants.
I'm sorry?
All you can do is draw an inference that no drugs came out of his pants as he was
Correct.
pat frisked.
Correct. I misspoke. What I was really getting at was the fact that there was also testimony that Mr. Bates was FIO'd and released. So I was really addressing a separate issue, that he was FIO'd and released, and that from that fact, a reasonable inference could be drawn that he didn't have drugs on his
What
person.
I-
Not
I know what the
No,
words-
wait a minute. You can't draw that inference. Can't draw
that he
that.
didn't have drugs on his person.
And so he gets asked, do you have drugs on your person? No. He gets pat-frisked, and there's not a bulk. As I understand it, the pat-frisk of this defendant didn't reveal, I mean, the drugs slipped out, but the big bulk of the 45 additional bags were not felt during the pat-frisk. Sometimes when you're patting for a weapon, you will feel.
Well, that's the defendant.
Yeah, that's what I'm
not sure we're
saying.
speaking of the defendant or
No,
Mr. Bates.
defendant. So the pat-frisk did not, I don't know whether the pat-frisk actually caused the 5 bags, but 5 bags dropped out, right?
Yes,
And
as the defendant. Yes,
and the 45 bags were not felt.
correct.
So it is possible that the other person was pat-frisked, and so we can't draw any inference that he didn't have drugs.
I do concede that point.
Okay.
You're correct.
You say that the other person was FIO'd. Is there evidence in the record as to what it means to be FIO'd? I mean, what is an FIO? I know what the words mean. I mean, what the initials stand for.
My best memory is that there was an explanation as to the fact that information is gathered so that, because there was some questioning about terrorism, that biographical information is gathered about the person to be used for intelligence down the line. So the answer is yes.
Okay, and did you ask any police witness how often his drug arrests had involved suspects with weapons?
Can you repeat that?
Did anyone ask any police officer how often his drug arrests had involved suspects with weapons?
No.
Okay, that would be a helpful question to ask in
Yeah.
trying to establish
Yes.
reasonable suspicion.
Yes, however, the facts of this case clearly demonstrate that there were specific articulable facts upon which the officers could reasonably base reasonable suspicion of criminal activity.
No.
Is that
Not
what we're
criminal activity, because
the
you're
pat-
pat-frisking for the weapon. And as far as I can see, the only thing you have is unsubstantiated testimony that there were shootings, plural, at some undefined time.
Admittedly, it is a close case. I think this is the Commonwealth's toughest hurdle here, quite frankly, is the pat frisk. It is a very
Oh,
close...
what about the lack of an expert? You don't think that's a tough hurdle?
I respectfully don't, Your Honor. And if I could turn to that issue, on the facts and circumstances of this case, expert testimony was not required as the Commonwealth presented other sufficient evidence from which the jury could have properly inferred that the defendant had the intent to distribute.
Okay, we all are in the
specifically-
criminal justice system, and we know that someone who carries a lot of individual packets of whatever it is, cocaine, crack, that they're very likely a seller. But how does some person on the jury who has no experience with drugs, doesn't know anything about drugs, doesn't even know probably that cocaine is a drug, is an illicit drug, how does that person know that because you have 50 packets that you're a seller, not a user?
From other evidence, such as, in this case, conduct or actions of the defendant.
Such
Such as the fact that the defendant was observed in a high-crime area. There was testimony, not just high-crime area.
Excuse me, I just have to say, I go to that neighborhood a lot, and I'm there late at night, fairly often. In the transportation building, in the theaters. I mean, this is not, I mean, you may call it high crime, but there are an awful lot of people who go there a lot and at night and late at night.
There are, but what I'm getting at, Your Honor, is that it was described as the hub, that the specific location of the intersection of Stewart and Tremont Streets was described as the hub of drug activity in that area. And
It is the hub if you're taking your granddaughters to the Nutcracker Suite. It is the hub of the theater district. It is the hub of restaurants. It is the
True.
hub of a lot of things.
True, but my point is that the testimony that the jury had was that it was the hub of drug activity, and under...
At 4 a.m., you leave out that the distinction is that this is 4 a.m.,
Well,
not
because I haven't
theater
even-
going time.
True, and you're absolutely right, and I haven't even gotten to all of the reasons yet, because I'm just trying to make the point that the fact that it was so described was the character of the neighborhood was relevant to the defendant's intent, and cases that this court has decided.
Wait,
has
I'm still struggling with the intent to distribute if you're a lay juror, and so this is a high crime area. Maybe he just bought his drugs there.
Okay, then I won't even start there. I'll get to his actual conduct, which is mid-December, over a course of a 4-hour period, from midnight to 4 a.m., just hanging around the street corner.
Looking
and
to
I'll leave out
buy,
the drug
looking to
activity.
buy.
But if you're looking to buy, it doesn't take 4 hours hanging around.
How does the
presumably.
juror know?
Well, then move on to his next course of conduct or action, hanging around throughout that time period, meeting in a huddled...
Excuse me, they saw him throughout the time period?
On multiple occasions, not throughout the entire, but the testimony was that on multiple occasions throughout the 4-hour period. He was observed at the corner of Tremont and Stewart Street. And again, as Your Honor, Justice
So reasonable
Cowan,
inference is that he was there all of the time, most of the time.
the reasonable inference is that he was there most of the time. The reasonable inference was that it was, the fact was that it was 4 a.m., or midnight to 4 a.m. The reasonable inference is that he was not there taking his granddaughter
Taking
to
in
the
a show.
theater. Correct.
It's a different kind of show.
Maybe. That's the reasonable inference. And really, the nitty-gritty here is that the point where he huddles into a dimly lit storefront, he outstretches his hand to display an item, not the second individual, he displays an item, and upon detecting or noticing police presence, he takes his hand and swallows what he had been displaying. Those, for even a juror who doesn't understand what a gram is or what packaging is, that kind of conduct, I would suggest, could be used to draw reasonable inference that he was selling, not drawing. It
He
also
could be
puts
showing
into
his
context-
buddy, look at this good stuff I just bought. I'm
But
saying
not-
from the
but-
juror's point of view.
but not
Look,
so-
look at this stuff I just bought. You go down the street and get a deal like I got.
But what we're looking at is the
And then
evidence
swallow
in the
it.
light most favorable to the Commonwealth.
No, 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 no. You need expert. I mean, I'm
Well, we're
saying,
on
how does the jury? That's not.
No, I
doesn't
understand.
apply.
I understand.
Okay, because I'm asking you how the jury knows without expert testing. I agree. Everybody in this room, who's on this case, knows, but
Well, I will turn to language from Commonwealth versus Rivera, where the
But not
court
at
said
4
drug
a.m.
sales are so common in present society that almost any witness could draw an inference that the drug sales were occurring when observing the activities as described. The activities that were
any
described.
witness.
I actually think that I wrote down, and I don't think it was any
Okay.
witness. I misspoke. The point was that any person could draw an inference, and the activities that were described in that case were items that could not be seen, conversations that could not be heard, but the observation of people repeatedly approaching, I don't recall specifically if it was a window or a door, but it was an apartment or residence, and getting something. So I think the court has found that drug sales are so common today that there is a general basis of knowledge that the
I
general...
don't think, I wouldn't go there. I wouldn't go there, because
Is your position that the more drugs a person has, the more likely it is that they're selling? That's boiled down. That's pretty much it, isn't it?
Well, it's the packaging also.
It's the packaging, it's the packaging, it's the quantity, it's the fact that in and of itself, what was observed may not be so compelling or telling, but it puts into context the fact that the defendant, or the intent or the purpose that he had in possessing 45 bags of crack and $80 or $70.
was there any expert
under
testimony as to how
that-
much a bag cost?
No.
So I don't know anything about cocaine. I really don't.
Okay.
Okay, but I've got a lot of money, and I live out in the suburbs, and I don't like to come in very often, and so, you know, I bring in hundreds of dollars, and I buy 50 bags of cocaine, and I'm left with $80. I mean,
It's the totality, it's the whole picture, it's the fact that the defendant had...
but I don't know that whether that makes me a buyer or a seller.
But you might know by displaying a small object in your hand to another person.
I may be
that
saying, is this cocaine? I know I'm doing something wrong, and I swallow. First of all, I'm not sure that, I mean, I don't know which way you can go with that unless you have somebody, and I don't know whether you would get an expert to say if you've got 45 bags, people don't buy 45 bags at the same time. Right? I'm a user. I'm not a distributor. I just use them, and I have to go down to this high-crime area late at night because I don't get them when the Nutcracker is showing, so it's high-crime. That's when I go down, and I buy 45 bags.
And you spend 4 hours in that area.
Well,
Well,
right,
that's-
thank you. That's right. It's the whole picture. It's mid-December, midnight, presumably cold,
Sure.
midnight to
Did
4
the-
a.m., hanging around and I know Your Honor didn't like it, but in the spot that was described as the...
No, I'm not.
This-
I don't mind the spot. I'm just saying, what's the influence? Can I just ask you one other question?
Yes.
I take it, did the jury have in front of them the facts of where the 45 bags were?
Yes.
Okay. And groin, does that mean
Under a roll of fat. The specific testimony was under a roll of fat in the groin area.
in your underpants?
Yes.
Inside the underpants?
There wasn't any testimony about underpants, but it was that it was
Against
in
the
a cell
skin.
phone case under a roll of fat.
Against the skin?
Yes.
Now, it would seem to me that that fact may be a little inconsistent with somebody driving in from the suburbs and
would have to
buying 45 packets, right? Because
I would have to agree.
I mean, I don't know if I could take judicial notice of that, but I might just put it into my coat pocket and not stick it down under a roll of fat. So the jury had that
That's correct.
piece.
That's
Okay. Thank you, Ms. Blaine.
If I just may, there was one point I wanted to make at the outset, and I didn't have a chance, but I would like to now, just very quickly, just about mistakes in the brief. It's evident that I did make mistakes in citing.
The way that we can handle this very straightforwardly is just send us a letter, and that'll be
That's all I say. Aaron, I apologize to the court for causing any confusion. Thank you.
a letter will actually be more helpful.
I will
Thank
do
you.
that.
Thank you, Ms. Brenner.
No, I'm fine.